Good afternoon. Welcome, everybody. I'm Veronica Alvarez, the host of this webinar. Thank you so much for being with us in our last class for 2023. And we are proud to have here two collaborators working with us. Today, we are going to talk about guardianship, and we have Michelle Morris from Consolidated Planning Group and Miss Melissa Donovan. She's a lawyer, and we love her having her with all her expertise talking about this topic. But before we get into that, I will talk a little bit about Partner Resource Network. So Partner Resource Network is the parent training and information centers for Texas. We are the PTI. We are funded by the Department of Education, specifically the Office of Special Education, to provide free resources and training for parents of children with disabilities and youth with disabilities that we call them self-advocates. Our mission is to empower and support Texas families and individuals impacted by disabilities or special healthcare needs. Who we serve? Parents of children with disabilities, youth with disabilities, from the ages from 0, since birth, to 26 years old. We serve in all the state of Texas. Partner Resource Network was first founded in 1986, so we were been working for a while. And now we have 4 projects serving parents. I'm part of the team project. As you can see in the map is the red area. The team project, we serve parents in Austin, in San Antonio, and in the Rio Grande Valley area. But if you are here visiting from another area and you don't know who's your regional coordinator, please type it in the chat box and we can give you that information for you to have. Our services are free and we offer a lot of trainings. We do workshops in person, we do webinars, information and referrals. We do one-on-one technical assistance. We do a lot of support in the AR meetings, and if you need help with your IEP, we can do that. Once a year, we do a symposium. We also offer parent leadership training, youth leadership training, and access to social media resources. So for today, some housekeeping items. So your camera and your microphone is off. So if you have any question, please type it in the chat box. Michelle is going to be monitoring that. Also, I'm going to do that. And Miss Melissa is going to help us with those answers. And we can, we can hear you in the chat box. Or if you can use the Q&A, it's more easy for us to follow the chat. But if you like to use the Q&A, we are going to be monitoring that. We are going to record this presentation and we are going to share that recording in our Facebook page. And also Consolidated Planning Group has a YouTube channel. In a moment, Michelle is going to talk about that. And at the end of this presentation, you are going to receive an email with a survey. Please help us with that. We need a feedback. With that, we can report to a grant and we can improve and continue to give you guys free services. We do not provide CEUs, but if you need a certificate of attendance, put it in the chat box or email me and I can help you with that. I can do a certificate of attendance if you need one. Again, this is my contact information. I already put it in the chat box. This is my phone number and email. Please visit our main webpage at www.prntexas.org. This is more contact information about the team project. This is our project director, Lisa Coward, and our my co-workers and regional coordinators in Region 1. We have Maria Cordero and Rosie Garcia. I'm in Region 13 here in Austin, and we have in Region 20, Aubrey Simpson. So thank you so much, guys, for being with us. And I'm going to start to share my screen. And now Michelle is going to talk about Consolidated Planning Group. And then Ms. Melissa is going to start our presentation.
Thank you so much, Veronica, for that great introduction. You are fantastic. as always, and thank you for hosting us. I really appreciate everybody spending the next hour or so with us to go over this information. I just want to quickly introduce myself and my company and what we do. I'm Michelle Morris with Consolidated Planning Group. We are a holistic financial planning firm that focuses on helping families who have special needs loved ones. We are located just outside of Houston, but we serve families all across Texas and all across the United States. We've been doing this for over 30 years. We work with, life insurance and securities, investments, all of that kind of thing. We are members of the Special Needs Planning Academy, and we are National Social Security Advisors. So we help handle the money side of things, whereas Melissa can help with the legal side of things and the paperwork. We help with the money side. On the next slide, some of the things that we help families with when we're talking about special needs planning, financial planning, we're looking at protection plans. How are you going to protect your family if you live too long or pass away early, or you become disabled along the way and you can't work anymore? How are you going to protect your family from those scenarios? We help understand the cost of lifetime care for your loved one once you're gone. Somebody's going to need to step in, and how much is that going to cost? We help a lot with transition planning, ABLE accounts, and of course, we are here to educate and advocate for you. There are, you might not realize this, but there are over 263,000 financial advisors across the United States, according to the Bureau of Labor Statistics. And out of those 263,000 advisors, fewer than 200 of us focus on special needs planning. That's fewer than 0.1% of all the financial advisors in the United States who truly understand the nuances of special needs planning. So you are definitely in the right place. So one major question that most people come to us with: who is going to take care of our loved one once we're gone? And we think it's very important that you start planning that as soon as possible. As soon as you know that there's a diagnosis, there's stuff that you can be doing to get ready. And the sooner you get started, the more impact you can have on your future. Now, we're not going to chastise you if you haven't gotten started yet. We don't look at the past too much. We're going to help you plan for the future. So we want to get you developing that future care plan. Start thinking about what's going to happen after high school. There are wonderful vocational options, residential options, educational options, but there could be waiting lists for those. So you want to plan ahead and think about that. And, don't just automatically assume that a sibling will want to take care of your child in the future. And don't just assume that your child will want to be taken care of by their sibling. This can create some tension in their relationship. And we would much rather have them be friends who help each other out instead of having that obligatory relationship. So just make careful consideration before you do that. No, it's okay, Melissa. So if you have questions on the money side of things, we have a slide later on that will tell you how to get your free consultation with us. But I'm here and you are here to listen to Melissa Donovan speak. So Melissa, I really appreciate you being here with us today to talk about guardianship. We get questions about this all the time. So thank you for helping us out. And feel free to take it away.
Well, thank you for inviting me. It's always a pleasure coming and joining y'all for these little presentations that I've learned to love to do over the last few years.
Learned to love. Come
and
on.
I will say, I shouldn't say learn to love. You will find out if you've never attended a presentation that I've done with these lovely ladies or anyone else. I love to talk, and I am from Massachusetts originally, so I also tend to speak pretty quickly, and I try to get through as much as we can in this hour that we have together. So bear with me, everyone. Okay. But My name is Melissa. I am a certified elder law attorney. I work with a firm here in Austin, Texas Trust Law, formerly the Wewell Law Firm. And I always like to say, because sometimes that title can be a little confusing for people, especially when we're talking about dealing with our special needs children. And my title as certification is certified elder law attorney. It's a little bit of a misnomer. Essentially what that means is that my particular expertise in the law, not only in estate planning, but is dealing with government benefits and special needs. And whether that deals with children or you're dealing with your elderly parents, as we go through slides today, you will notice there are some particular areas where we provide a little bit of information and thoughts on if you are dealing with this from a different perspective, because the bulk of this presentation is going to be talking about, do I need a guardianship for my child? And if there are a lot of you out there in my age range, we are starting to get into what we refer to as that sandwich generation. So you might be responsible for children and you might be getting ready to be responsible for parents too. So it'll be helpful information regardless, and we'll throw little tidbits in there for your parents as well if necessary. But we are here to talk about guardianship. And I get this question a lot, and I get this conversation a lot because there is a lot of unknowns. And I talk to a lot of people who think they absolutely need a guardianship because they've been told that by everyone everywhere and every website that they have Googled. It's like our version of WebMDing. Not everyone needs a guardianship. And then I've also talked to people who they don't really think they need a guardianship, but they do. So there's a whole spectrum of what we're going to talk about here. But the crux of the point is, what is a guardianship? Do you need it? Why or why not? And I always have to preface any presentation so everyone understands that I am not your attorney. I cannot technically provide each of you individual legal advice. This is meant to be educational in nature only. But guardianship, what it is it is you legally able to continue to make decisions for your children as they become legal adults. So the way I explain it to all of my clients very easily is, guardianship allows you to continue being their parent once they turn 18. That's essentially what a lot of it is. Now, there are different forms of guardianship, and we're going to talk about those different things as we go through, but you may have heard this term, less restrictive alternatives, especially if you are particularly involved in the special needs community. You attend a lot of events, if you do a lot of support groups and things of that nature. This is a very hot topic, and it's an important one. Because guardianship, not only is it not always the best route, sometimes you cannot get it. And that's where these less restrictive alternatives do come into play. And we're going to talk about that as well. But when it comes to raising a child with special needs, kind of like Michelle had pointed out, there's all of these different things that you need to think of. In my opinion, there are two very, very difficult things in this world. It is being the parent to a child with severe special needs and everything that you think you need to figure out. And most of my clients feel like they have to figure it all out at once. And it's important that you understand you want to get these things done, but don't overwhelm yourself. You can take your steps and take your time on these things, but you do want to consider who is in your circle, essentially, to provide the support for all the things that you do want to think about. Do you have an attorney for special needs situations? Do you have an attorney for your estate planning? Have you thought about guardianship? Do you have, like Michelle was saying, a great financial advisor who actually knows all the ins and outs? And I can attest to what she was saying. I have been doing this for a while now, and it is very difficult to find financial advisors who really know what they're doing in this arena. And I work with some really great financial advisors, but when it comes to special needs, they are one of the best. Okay. And they are few and far between. Okay.
Thank you so much.
Outside of that, you're welcome, deserved. Outside of that, sometimes you got to deal with CPAs, you got doctors, you got counselors, you got a lot of people coming in and out of your life and part of your circle. But this kind of gives you an idea of the things that over time, you're going to want to develop all of these things. We're going to want to talk about your estate planning. You're going to want to talk about, do we need special needs trusts? Today, we're going to talk about guardianship. If you want to talk about all those other things, there are plenty of other presentations and videos on YouTube that you can watch on that as well. So let's explain and kind of go to basics. Why do you actually need a guardianship? So when your child turns 18, as much as pretty much any parent is going to say 18 doesn't necessarily mean that my child is an adult. Sometimes 25 doesn't necessarily mean your child is an adult in your eyes. Legally speaking, they are. And the minute that your child turns 18, technically and legally speaking, you don't have any authority for them any longer. So if you call the doctor one day and they don't want to speak to you, you can't force them to, because your child has rights at 18, your child is an adult, and you no longer have the authority to speak for them, make decisions for them, essentially do all of the things that you have spent all of these 18 years helping them with, that in a lot of your cases, probably your children can't fully do it on their own. The question is, how much help do they need? Okay. And with guardianship versus a supported decision-making agreement, or even my regular estate planning clients, when their kids turn 18, we advise all of our clients, when your kids turn 18, they go off to college, get them a simple estate plan. And that sounds kind of scary. And for some people, I understand by using the term estate plan, it sounds like a little overkill. It's just a fancy way of saying, get your kids some basic documents. Make sure they've got powers of attorney in place. Make sure you have a HIPAA authorization so that you can talk to the doctor. Because I don't know if anyone else went through this, but I myself remember when I went to college, and I started college a little young. I was 17, so my mom could do the things for me my first semester. But then the first time I asked my mom to make a doctor's appointment my second semester freshman year in college, I was like, what do you mean you can't make it for me? I don't want to make it. So all of those little things, regardless of whether your child has special needs or not, those are things that are good to have. Now, if you have a child that has special needs, they may not be able to sign those documents. That's where these things come into consideration. That's where we need to figure out, if I have a child that has a condition that prevents them from understanding what it means to put me in charge of things, meaning they won't understand what it means to sign a power of attorney. If I have them sign a statutory power of attorney, a financial power of attorney, a medical power of attorney, will they understand that they are putting me in charge of decisions as opposed to them making those decisions or making those decisions with them? If you don't believe that your child has the capacity to understand those things, then that's where you need to start having that conversation. And I tell all of my clients, the best place to start that conversation are the people surrounding you now. The doctors, the teachers, counselors at school, or any other counselors that you see. It's a good idea to start having those conversations early. Now, you don't have to have them when they're 13, but start having those conversations when they're maybe 16, 17, start thinking it through and start trying to make those determinations as to, what are things going to look like as we start to get towards 18? Do we need to go this route of guardianship? So these are the things that you want to consider when you're thinking that route of guardianship. So the biggest one is, what is my concern? Meaning, what is my child's situation? What's the health diagnosis? What is the future prognosis of this? And what are the limitations that means for my child? Beyond that, then we want to think about, is it a temporary or is it a permanent thing? And I say this every time I teach, no matter what. We talk about permanent guardianship versus temporary guardianship. And I am the first person to tell you that not even permanent guardianship is permanent. So when you hear that term permanent guardianship, I never want it to scare people off, because guardianship has to be renewed annually regardless. So don't let the terminology scare you and think, once I do this, we have it forever. If you need it forever, you will have it forever. But if the concern, the diagnosis gets better, your child improves, their cognition improves, maybe you don't need it 5 years from now, and you can always get rid of it then, okay? Then you want to think about, like I mentioned earlier, who's your team that you have in place? What are the resources around you? Sometimes the resources you have around you are enough to prevent you, at least for a little while, from having to go and get that guardianship. The biggest thing, though, is the capacity level of your child and their abilities and their limitations. And the biggest concern I typically get from my clients, particularly from people whose children are kind of on that edge where it's a very gray area, there are always going to be the very clear, yes, we need guardianship, and the very clear, no, we don't. A lot of people are going to be in that middle ground where it's not clear. And maybe some days it seems like we do need a guardianship, but other days we don't. Maybe we feel like our child basically has an understanding to sign things, but our biggest concern is they can understand to sign a document, but someone's going to easily take advantage of them the second they can. So there's all sorts of concerns, and these are all important parts of the conversation to have, whether you're having it first with the doctors or counselors or whatnot, but gather as much information as you can in those couple of years leading up to your child turning 18 so that you are putting yourself in a better place to make that determination when the time comes. So types of guardianship. So I mentioned this earlier. You'll see at the very bottom here, you've got temporary guardianship. We are not going to spend really any time beyond this short snippet talking about temporary guardianship today. Temporary guardianship are things that are done because of an emergency. This is where you see those scenarios where like an elderly parent has an emergency thing, we've got to place them in care or something to that nature, and someone's got to go to court and get guardianship very quickly for a very specific circumstance. That's not what we're going to talk about today. We're going to be talking more about permanent guardianships. And in guardianship, so here in Texas, we refer to any type of guardianship as guardianship. So if you have moved in from out of state, you might be familiar with the term conservatorship. A lot of other states, what we refer to as a guardianship of the estate, other states will refer to as a conservatorship. So in some states, they'll say guardian and conservator, but what they really mean from a Texas terminology perspective is guardian of the person, and guardian of the estate is what they refer to as the conservator. So the difference between those two things, like I said earlier, kind of allowing you to continue to be the parent, that's your guardian of the person. That's the person that's going to figure out where they're going to live, make medical decisions, assist with schooling decisions, do all of the things, like I said earlier, as a basic tenet that you do as a parent every day until your child turns 18. And for many parents, even beyond when they turn 18. Guardian of the estate means that you are managing money that is in that individual's name. So let's say you have a child that has an accident or something occurs where they come into a sum of money, but they're minor, so they can't manage the money themselves. So whether that's an accident in a settlement, or if it's like grandma or auntie or uncle passed away, just leaving them money inadvertently. So maybe there's $20 or $30 or $40,000, and that is now under a guardianship of the estate to manage for them. That's money. Guardian of the person is managing decisions for the person, those medical type decisions and living arrangements. Guardian of the estate is dealing with money. So the full guardianship, this kind of gives you a rundown of what it means. So as harsh as it might sound, but I think it's very good for people to have a realistic point of view on what this is. You are, when you obtain guardianship, essentially taking many rights away from the individual, which is why these days, most courts, as much as TV and Netflix specials about Britney Spears might want to make you believe otherwise, most courts don't want to issue guardianships. This is where we have things like lesser restrictive alternatives and where those things interplay. Because if we can figure out a way to allow the individual to live their life as wholly as possible, as safely as possible, without the court having to get involved, they want you to do that, okay? At least I can attest to the Central Texas area. None of our judges here are dying to put people under guardianship, maybe in a Lifetime movie, I'm not sure. But this gives you an idea of things that your child would no longer be able to do. So as a general rule, they're not going to be able to vote. They're not going to be able to drive. They're not going to decide where they live. They're not going to have firearms. You decide if they marry or do not marry. All of these general things. And then of course, the biggest one for most of my parents, the medical treatment, all of those things that have to be handled, okay? Now, there are things that you can do where in some circumstances, you don't have to take all of those things away. So I'm just going to go back for a second. So for example, I have had some cases where the person could actually drive. It was an odd one. It was actually just one case, and it was rare, but everything else we could not allow for, but they wanted their child to continue to be able to drive. They had a license. They had the capability of doing so. You can do that. You can kind of, as much as I hate to say pick and choose, there are some things that do make sense that a person who needs a guardianship for all other purposes needs. The most common one that I have seen is voting. And some of that is not realistically that the child really wants to vote, we're not trying to get political here, but I mean, most 18-year-olds don't really want to get involved in those things, but it was more so about the attorney on the other side who just didn't want them having that right taken away from them. And they were allowed to keep that right. So what does the process look like when it comes to guardianship? So depending upon what county you're in, all of these things, the duties that you have, what obligations you have in the process of it, are generally going to be the same. Some things are going to be tweaked area to area. So for example, you'll notice that second bullet point here that talks about bond and it says it may require bond. Different counties are different. So I'll give you an example in Central Texas. Here in Travis County, for a guardian of the person, Judge Herman will always require a $13,000 bond. Now it's not cash, it's a bond. It's basically an insurance product that you go and you buy, okay? Most of your larger counties, the counties that have statutory probate courts like Travis County does, are going to fall pretty similar to that. Another example, Williamson County, just north of us, okay? In Williamson County, they just require a $100 cash bond for the parents in most cases. Now, it's up to the court to determine what's reasonable and what they feel comfortable with. So that's why it kind of depends on the county. I have had guardianships in Fayette and Bastrop County where they have required no bond of the parents. So it's up to the judge to decide in each county, okay? But the duties that you have are going to remain. It is your obligation, and no surprise here for all of you parents out there, okay, to provide care, supervision, support, and safety for the person that you have guardianship over, okay? Like I
Miss
said,
Melissa, we
yes.
have questions about what is a bond? We pay 13K for the bond, or is a different amount?
So a bond is essentially an insurance product. So no, if you're purchasing a bond, you are generally not purchasing it for the value that it is. So I can speak to the bonds with the companies around here and what we use with our clients. It used to be a little different. So kind of like most insurance products, different things come out over time and hopefully they're better than they were before. It used to be about $175 a year for a $13,000 bond. Now they have a permanent bond, which essentially means so long as you are the guardian, that bond is going to cover you for the entirety of that guardianship. And at this point, that bond is about $375. So rather than having to pay $175 every year, most of my clients are paying $375 one time, and then they keep that bond for the entirety of that guardianship. Now, if somebody else becomes guardian because, let's say, a parent gets older, they don't feel like they can handle it anymore, or someone passes away and a new guardian needs to be appointed, that new guardian will have to go and get their own bond. So it stays with you as the guardian, okay? Now, I've noticed a couple of other questions come in, so if you're okay, I'm just going to kind of answer those because they're kind of in line with what we were just talking about. There is a comment about the having to post a bond. This is a comment that you are not alone in. I know it seems a little crazy that you have to spend money and post these bonds. It is a requirement of the court, and sometimes it helps to explain why. The purpose of that bond is there to protect. I hate the term, but sometimes I have no alternative to use it. So when you're dealing with guardianship, you'll notice it within the PowerPoint here. The term that they use for your child is ward. So the purpose of the bond is that you as guardian are responsible for your person under guardianship, is the way I like to put it. And the court is responsible for you. So while generally speaking, parents are always going to do what's right for their children, and it is very rare for something to go wrong, as they say, if something does go wrong, that bond is there to protect you and the court, essentially like a life, not a life insurance, but like a homeowner's policy is there to protect you from someone getting hurt on your home. It is similar in nature if you think about it from a theoretical perspective. Now, the other question that I had here was about powers of attorney and supported decision-making agreements, and we will get into those in a moment. So we'll come back to that, okay? Now, the guardian of the estate is a little different, and this is something that I always try to avoid as much as possible with all of our clients. So the difference from a practical perspective for you as the parent and having to be a guardian of the person versus a guardian of the estate. The guardian of the person, once you have that guardianship in place, it is a one-time a year annual accounting to the court. It's about a 6-page document that you have to fill out, basically attesting to the well-being of your child every year, and as to whether or not that guardianship is still going to be necessary. So they will ask you things like, where is the child living at this point? Has there been any change in their diagnosis or their treatment? Are they, are they doing better? Are they doing worse? Are they doing the same? Do we essentially still need to keep this guardianship in place? Beyond that, there's not much further court involvement. You will get court visitation every once in a while. It's rare, maybe once a year. But when you have a guardian of the estate, you are so much more intimately intertwined with the court on a regular basis because of the way that the rules work with guardian of the estate. So with the guardian of the estate, you'll kind of see here, there's a lot more detail about that process and what you need to provide. Your bond might have to be higher when you're dealing with a guardian of the estate. And you have to get approval from the court for many things. So unlike with a guardian of the person, where essentially for most things that you would do on a regular basis, I don't want to say you're on your own, but you can make those decisions. With a guardian of the estate, you have to set essentially an allowance, you have to set a budget, you have to get court approval on those things. If we can avoid that, we want to avoid that. And the way that we avoid that is that your child has no money, no assets in their individual name when they turn 18. If we can do that, we avoid that guardian of the estate. Now, the good news on that is that they have increased the numbers in the last legislative session. So it used to be that you did not need to have a guardian of the estate unless the child had anything over $2,000 of assets in their name. That was the kind of de minimis amount that the court said a guardian of the person can manage that. They've actually increased that quite substantially this year, up to 20,000. So that's a really big help for a lot of people. Still, personally, I prefer that clients not have assets like that in their child's name. And for most of my clients, we're not just dealing with guardianship, we're dealing with government benefits in addition to that. So having that amount of money in the child's name is problematic for a whole other host of reasons.
Exactly. I was going to bring it up, so I'm glad you said that.
Typically try to avoid that. Okay.
Yes.
Now, sometimes things happen, we can't avoid it. And maybe we'll have time to have a discussion about able accounts, but those are a good reason to have able accounts too. So the initial process, the biggest question I always get, when do I have to start? How soon do I have to start? Typically, you don't want to start this process any earlier than 6 months prior to your child's birthday, but it's a good idea to start within that 6 to 4 month window. Okay, so between 4 months and 6 months before your child turns 18 in most areas. The thing I like to make sure everyone is aware of, you cannot technically have your hearing until your child has actually turned 18. But there's a whole bunch of stuff that has to happen before you get to that point, okay? So we've got to put in an application, we've got to get doctor's certifications, there's all of these things that happen. And a general overview is your doctor has to have a certification that this is necessary. In most areas, in the bigger counties, this is done through a general form, okay? And it's a form that if you're typically your attorney will give to your doctor, they fill it out, they make their determination as to the necessity. Once we have that back, we put in an application to the court to get appointed as guardian. Now there's 2 attorneys involved in every guardianship. There's your attorney, because the attorney that you hire to represent you cannot represent your child, they represent you. So the court appoints what is called an attorney ad litem. And the job of the attorney ad litem is to represent your child. Okay, because when you're saying we need guardianship, inevitably what that means is that your child, and especially if your child is under 18 when you put in the application, in addition to that, your child doesn't have the ability to go and hire their own attorney. That's why the ad litem is there. The court is appointing one for them. Now, once that ad litem is appointed, what will typically happen is that your child will get served as well. So there are ways to avoid having to serve or do process on other people that maybe under the law should be served. But the one person that will always have to be served by a constable, and sometimes this is a little scary for clients before it's explained to them, is your child. Because we have said they don't have the capacity to waive that, okay? And for the most part, what I try to make sure my clients are aware of is that the ad litems and the constables that do these process of service are generally speaking people who have done this a time or two before. So they try to be as sensitive as possible. Now, we all have bad days every now and then, but as a general rule, they're going to work with you as the parent in terms of finding a good time. When can they come? When process is served, you can be with your child, but they need to physically hand it to your child. And all that is, process of service is just them handing a copy of the application to your child saying, this isn't happening. Someone's trying to get guardianship for you. It's not that scary, but I understand that it can seem kind of scary, and particularly for your kids, and depending upon your children's condition, it can be scarier for some than others. Once that happens, the ad litem is going to interview your family. So they're going to interview you as the parents. They're going to interview your child that you are seeking guardianship over. If there are other adult siblings, they're going to interview or ask to speak with the other adult siblings, particularly if they are in the area. They, generally speaking, don't ask to speak to minor children that are siblings, but if they're there and you're comfortable with it, they might just talk to the family if it's something you're comfortable with. But their job is to get a feel for what your child's needs are so that they can help in that determination process of whether this is necessary or not. Their job is to stick up for the rights of your child. Once all that is done, you can have your hearing. And every situation is different. Okay, so some situations your child can attend court and they're able to somewhat interact and be part of that process. Most of the time with my cases, that's not something that has occurred. Maybe once or twice I've had a client actually in court for the hearing. It just all depends on what is in the best interest of your child. And that is something that is determined both in the initial process of applying and reviewing those doctor's reports, and also by the ad litem after their conversation. And sometimes there's a disagreement. I have had it happen where I have said, I don't think that the person should be there. I don't think it's in their best interest. My clients don't think it's in their best interest, but the ad litem thinks it might be. So the one thing I always say about guardianship too, particularly because most of the work that I do in terms of guardianship in this arena is what we call uncontested. It's probably what a lot of you are here to looking at right now. It's parents trying to get guardianship over their child as they turn 18, and probably no one's going to contest that. Your other child's not going to try to say, no, you shouldn't be guardian. The way I like to put it to all my clients is when we go into a hearing, because sometimes this is the first time that you've had an interaction with the court. Being in court is not something that most people want to do. Honestly, it's not something even most attorneys want to do. That's why you hear all this like settlements always happen. People don't want to go to court, but the way I word it to my clients, and I don't know if everybody else out there or other people out there are Law and Order fans like I was, but what I always say is, this is not Law and Order, and I am not Jack McCoy. It's not scary. No one's trying to get you. No one's trying to trick you. Everyone there are people that do this for the most part on a regular basis, and they're there to do what's right for your child, and they're not trying to trick you into anything. Judges, particularly if you have statutory probate courts in your area, are really sensitive to what's going on. Judge Herman here in Travis County is really amazing. Judge McMasters in Williamson County is great as well. But they're sensitive to the situation. Don't walk in there feeling like, oh my God, I'm going to have a scary judge beaming down on me. It's going to be like my cousin Vinny. Everyone's going to be yelling. It's not going to be like that. It's going to be very collegial for the most part. Now, there are some people that cannot be appointed as a guardian. This has changed a little bit with recent legislation. Most people in the past have kind of used this person with a history of notoriously bad conduct. This is, for the most part, where people say you can't be a felon and be a guardian. It's a little different now under new changes in the law, but it's very case specific. But the biggest thing is it can't be a minor, clearly, and it can't be someone who has a negative conflict of interest with the child. So like someone who is suing the child can't be their guardian, for example. So we're going to come back, because I know I said earlier we had that question about powers of attorney, supported decision-making agreements. All of those things fall under this umbrella of less restrictive alternatives. Now, if you have a child who has the capability of signing these types of things, that is great. For the most part, that means you are probably going to avoid needing to have a guardianship in place. And the other thing I always like to say is, just because you try one thing now, if it doesn't work out 2 years from now, doesn't mean you can't go back and try to get guardianship. And courts are always going to appreciate that you have done everything you can to try to make things work without having the guardianship in place. So sometimes rather than saying, I need the guardianship, we're going to get the guardianship right now, because a lot of people are very concerned. Well, like, as soon as my kid turns 18, I can't do anything, because I know I said that earlier. But if you can do these things, then you can maybe try to make it work. Now, eventually, even with these, you might get to a point where you're going, it's just not working anymore. We need more restrictive things on here. But you can always try these things out. So a durable power of attorney, that's your financial power of attorney. Okay. So that's the document that someone signs saying, I will allow for my mom, my dad to access my bank accounts, write checks, make financial decisions for me. A durable power of attorney, if done appropriately, is going to be effective the minute your child signs it, which is key, because you can do what are called springing powers of attorney, which means that those are only able to be used if your child is actually deemed incapacitated. We don't want that. We want to have a durable power of attorney that's effective the minute that it's signed, because that's going to allow you to manage assets in your child's name without having to go to court, without having to get any kind of guardianship. Anything in their name, you can manage, even if they can manage it themselves. Same thing goes for, like, if your parents have a power of attorney, you're their power of attorney. If it's a durable power of attorney, my mom doesn't have to be incapacitated for me to help her write a check. Okay. Medical power of attorney is a little different. And this is where supported decision-making agreements came in. Okay. Because the key difference between medical power of attorney and financial power of attorney, other than it being medical and financial, is that a medical power of attorney by law is only effective when the individual cannot make a decision for themselves. That's the kicker. If a doctor says your son or your daughter has the ability to tell me what they want to do themselves, you can't override what they want to do. Okay. Now, if you have a HIPAA authorization, you can talk to the doctor, you can gather information, they will speak to you, but whatever your child says goes. And that might not always be what you want to see happen, because you might have scenarios where, yeah, they are not incapacitated technically in the legal sense of the term, but they really don't have the ability from a practical perspective to be making the correct decisions for themselves. So this is where those supported decision-making agreements came in, because the purpose of a supported decision-making agreement, the key is it doesn't allow you technically to make decisions for your child. And this is where I think for many years, people really were hesitating on these agreements. And most attorneys that I know, and even myself, to be completely transparent, wasn't sure that these were really worth anything. Okay. Because it's not allowing you to make decisions for your child. But for someone who doesn't have any capacity, the initial question is, what is the purpose here? If someone has enough capacity that we can sign documents, let them sign documents. And if they don't, get a guardianship. But this is why they're there. Medical power of attorney. And the other part of this is schooling, sometimes employment, any post-secondary continuing programs, like programs where your child continues on till 22 or things of that nature. It's going to allow you essentially to be an information gatherer and help your child make a decision. So it still puts the onus on your child, and it can be really helpful because it allows for you to have the capability to get information, to guide your child, to help them make the decision by telling them points of view, giving them all of the information, walking them through it. But then ultimately, it's also giving your child kind of that ownership of feeling like I made a decision, which is really good. And I think most people in this community would agree. Most people don't want their children to feel like they have absolutely no independence and no ability to make decisions for themselves, no autonomy. You want to be able to do that where you can. Now, do supported decision-making agreements work for everyone? No. If you're in a situation where your child has not a high enough level of capacity to understand and sign that document, then it's not going to work. You've got to go guardianship. But there is a little bit of an in-between space between having the capacity to sign a contract and having no capacity at all. Okay. And that's where these supported decision-making agreements come in really helpfully. I have had most of my clients that we've done these things for have been either kind of mid-range autism situations. I've even had one client where their child did have Down syndrome, but we had enough of an ability to get them to sign this, and then you can try it for a little while. Okay. My experience has been that over time, more and more third parties are willing to work with parents on accepting these supported decision-making agreements. Initially, just like with anything else that might come up in the law, when it's new, people are hesitant to work with them because they just don't understand them. They're not sure how they're going to work out. But supported decision-making agreements have been around long enough at this point where you're really starting to see them take a little bit of traction, and people are accepting them, people are working with parents on them. But as I said earlier, if you go this route, and you try out the powers of attorney, you try out the supported decision-making agreements, and a couple of years go by and you're noticing it's really not helping, you can always get guardianship at that time. The
And
kicker,
Miss Melissa, all these alternatives, it has to be done also by the help of a lawyer.
so I would typically advise that it does include an attorney, because an attorney is going to be able to guide you through these things. However, you can do most of these documents. There are organizations that have the documents available for you. You work with an attorney because of the guidance and the support that the attorney is going to offer to you in customizing things for your individual needs. Okay. Now, this goes through, I know I spoke a whole lot about them. If you want to actually read statutory code, because that's what you do for fun, this kind of gives you an idea of that. But in terms of who can enter into them, this goes through what we've talked about earlier. So essentially, your child just has to be able to understand that they are asking for help and allowing you to help them. It is a relatively low level of capacity that's needed to sign those supported decision-making agreements. So this goes through what you are actually allowed to do as the supporter. Okay. And as I said earlier, and you'll notice it big and bold, it does not allow you to make decisions for your adult child. It allows you to help them make the right decision for themselves. Okay. So when we're talking through that, okay, you want to go back to what we talked about at the beginning. Why might I need a guardianship? Will a lesser restrictive alternative work? You want to kind of sort through all of those things as soon as possible. Like I said, not when your child's 13, but between that age of like 16 and a half to when they turn 17, that's a great time to really seriously start considering these things. If you start thinking about them too early, it's one of those things where you never know what can change in a year, let alone 3 or 4 years. So what I never want to see clients do is, and I understand because some people are more of planners than others, but you don't want to work yourself up when your child is 12 or 13, when you don't need to work yourself up just yet. You want to focus on the things that are important in that time and keep in the back of your mind, I need to think about this eventually, but maybe you don't need it to be your primary focus right now. Okay. So some of the things that you want to make sure that you are doing, and I think we did have some additional questions that I'll come back to here in a second, but you want to reach out to your support group. Okay. This is a really good support group. Okay. And your family around you, your friends around you, any organizations that you are involved with, all of them can help. Okay. This is where I kind of say, if you have older parents, maybe think about that too. You want to think about what their planning is if you're in that sandwich generation, like I talked about. But you want to map out a plan when it comes to your kids. Like I was saying, you don't necessarily want to have all of your planning set in place for guardianship, and this is what we're going to do at 13. But keep it in the back of your mind, kind of like your general time frame of, I need to make sure I've got these things done by these times. It is really important when you have a child with special needs, baseline, for you to have good estate planning in place for yourself. Because what you do not want to have happen is that you are doing everything you can to take care of your child. You go and get the guardianship. You do everything you have to do, except you never get your estate plan in place. So you don't do your wills, you don't do a trust, you have no special needs trusts in place. And not everybody necessarily needs a special needs trust, but those are things that you want to start talking about sooner rather than later, because you want to
With-
make sure.
With
Go ahead,
us,
Michelle.
with Consolidated Planning Group, right?
Yes. Now, I think that we will spend some time. This is perfect, because we've got a little bit of time to go through some of these questions. So I'm going to kind of go back through here and come back to some of these questions that y'all had asked.
Well, Melissa, let me, if you don't mind, I'll speed through the rest of my slides because I do want to
Go
make
for it.
sure you have enough time. But I also want to make sure that people know and understand that we do offer a free consultation at Consolidated Planning Group. And because, we put on these webinars, you registered for this webinar by giving us your phone number and email, you will be hearing from us. And we're calling not to be annoying, not to bug you, but just to let you know that this free consultation is available to you. It's through Zoom. They're usually about 30 to 45 minutes. Our goal is to answer your questions, learn about you and what you're going through, and then talk to you about what we do, what our fees are, how our process works. And we don't bite, I promise. We're not pushy. We're just here to have a chat and a conversation and decide if it's a good idea for us to move forward. So when you hear from my team, like within the next few weeks, please don't be rude. Don't hang up on them. A no thank you will suffice, or better yet, just go ahead and set up a chat with us. It'll either be me or Allison or Andy who you'll talk to, and we'll answer any questions that we can for you. So I just want to put in that little plug. And now, Melissa, you can go back to any questions that are in there.
Okay. So there's a couple of comments here. So there was a comment here dealing with trustee and guardian of the estate. Being a trustee is not being a guardian of the estate. A trustee is someone who manages an actual trust that is in place for that child. A guardian of the estate is a person that is appointed by a court to manage money that is in that child's name, meaning it was never in trust. So this is why it is so important for you as parents to do your estate planning properly, because you don't want anything that you own to go to your child outright, which would cause a guardian of the estate. You want to make sure that your estate planning provides properly for your children, that there would be a trust and then a trustee that you are designating. That's the difference of that, which does kind of flow into one of the other questions here about if I have an adult child with child support. If there is a child support payment, this is not necessarily about the guardian of the estate question. This is about Social Security, and this is about Medicaid, okay? Because if you have, let's say, a child who is 19 and you have an ex who is subject to child support payments, those child support payments are technically your child's money, even if they are coming to you as the parent. So in that situation, and typically you want to make sure that this is being done as part of the divorce process. This is something that is a little bit of a passion project of mine, and several other attorneys in the area is reaching out and explaining to family law attorneys how important this is in divorce decrees. The divorce decree should basically say within it that any child support will be payable to a special needs trust. Now, that special needs trust is going to be what we call a first party special needs trust. I know it's a little bit outside the realm of the guardianship, but it's worthwhile to just go through it a little bit while we're here. So with special needs trusts at a base level, there are first party and third party trusts. First party means that the money in that trust is technically the beneficiary's money to begin with. So that's where we have the biggest example most people are familiar with is if I have a child that, let's say there was a medical malpractice thing when they were born, so there's a settlement that came in when they were a young child, that's typically going to go into a first party trust. That money is your child's money, but we don't want that settlement to cause an inability to get benefits. Same thing here. If we have child support payments past the age of 18, that is your child's money. But because it is unearned income, that money can cause severe detriment to Social Security benefits, and then Medicaid. So that's why you want it paid to a first party special needs trust. You don't want to put your money in a first party special needs trust because the main difference, other than, okay, why is it first versus third, is that with a first party trust, when your child passes away down the line, the money in that trust is going to be paid to Medicaid to pay them back for the services that they have rendered during your child's lifetime since that trust was created. If you are giving money to your child, you are never going to put it in a first party trust. You are only going to put it into a third party trust, because third party trusts are meant to hold other people's money that will never go back to Medicaid. Okay, so that's the key. If it's your
It's
money, your money to
you
provide for.
cannot put it like they deposit that money in an ABLE account because it's the same thing.
So there's a difference between could you and should you. You can put it in an ABLE
Very
account,
much so.
technically speaking. You should not put it in an ABLE account. So I am a very strong proponent of ABLE accounts because they definitely have their uses. They are wonderful for specific purposes. But you never want to purposely put money into an ABLE account just because that's how you're using to give to your kids. ABLE accounts should be opened, in my professional opinion, by anyone who has a child with any kind of special need to be used in case of an emergency. So those examples like I used earlier, like auntie or grandma dies, leaves like $5,000 in the will to your child, there's no trust. If you get that money through that inheritance, but you have an ABLE account, you can toss it in the ABLE account and nobody's going to be looking at it anymore. Those are awesome uses for ABLE accounts. We also use ABLE accounts within special needs trusts in terms of, I shouldn't say within, but in conjunction with special needs trusts, because there are some things that we can pay from ABLE accounts without any loss of benefits that if it came from a special needs trust directly, it would. So I would highly suggest that all of you sign up for the next special needs trust webinar to learn more.
Yes.
I'm going to become a YouTuber, you know, that's what they do, right? Watch. But that's the ABLE account side of things. They are great for little amounts of money, but ABLE accounts do have that same Medicaid payback provision. So we want to avoid money going into a place unnecessarily that could go back to pay Medicaid when it didn't belong to Medicaid in the first place. That's the main difference there.
And then when parents got the guardianship for a renewal, each year you go and pay the court $25 and you have the document each year, stuff like that. But there is another option, I think you mentioned it, that you pay a little bit more and you have the document for more amount of years, something
So
like that.
it's not, so you still have to renew the guardianship annually. You get your letters. So when you get guardianship, you get what are called letters, okay? And the letters are the actual permission slip from the court. So that's what you provide to third parties whenever you're needing to do things for your child. So those have to be renewed annually, and there are court costs involved in getting those each year. It's relatively minimal. I would say no more than about $50, depending on how many letters you want to have originals with you. The fee that we were talking about earlier was the bond. So for counties that require that bond, you can, honestly, I don't even think the companies that we work with here in Travis County any longer even offer the annual pay ones. They all just use the full pay one. That's going to depend on the agencies in your local area. But that's also going to depend on what county you're in. So like in some counties, it's just a cash $100 payment and it's just a one-time payment anyway. It depends on what county you're in and how they do their bonds.
We only have 2 minutes left. So, well, 1 minute left. So Melissa, I want everybody to make sure you have Melissa's contact info, but then if you would just flip to the last slide where it has our QR code, and let people use that if they want to schedule with us real quick. Just for this last minute, if you want to grab one more question, and then I think after that, if people don't have any if they have more questions and you weren't able to get to it, they can just reach out to you, right?
Yes. So I'm going to answer this very last question that came through because I think it's an important one to clarify. And the question is there a way to get full guardianship without having to visit the court annually? And the other part of that is making my son a ward of the state. When we use the term ward, that doesn't necessarily have the same connotation as when people say ward of the state, okay? It's just the terminology that the court uses. You have control over your child when you obtain guardianship. You cannot obtain guardianship initially without going to court. And how formal that process is in terms of the hearing is going to depend on what county you're in. Some counties are more formal, like your larger counties here in Travis County, it's a little bit more formal. Some of our smaller counties around us, you sit in the judge's office and go through this. So it's just every county is a little bit different. But the thing I want to make sure is very clear is you are not going to court every year. You are filing paperwork with the court every year once you have the guardianship. So most courts will send you out that notice about 60 days in advance of when it's due. And then you'll file that paperwork and you will request the court to send you some additional letters and you'll pay the minimal fee that they have. So it's not about going to court annually, it's just paperwork you have to file.
You've made people very happy with that announcement.
I did see
It's just one time. And
I
then
think
just
one
renew.
time in court.
What happens if you miss filing that paperwork? The
So
child
if-
has no guardian?
The guardianship can lapse if you don't file the paperwork within the time frame as you need to. Now, do things happen and sometimes people just forget? Sure. And again, I can't speak for every county, but for the most part, they will try to do what they can. But if you wait too long, and you will be notified. Don't you worry. If you don't file the paperwork, you're going to be notified because they will terminate the guardianship. And then if that happens and you go too long, you're going to have to reapply and go through an entire initial process all over again. So you don't want that to happen. So you just want to be cognizant. When I do guardianships with my clients, every attorney does things a little bit differently. When I do guardianships with my clients, once we have the letters, once we have finished the hearing, all of my clients get a binder with everything they need. They are told, this is what you need to do every year. We give you a copy of the form. Now, as I tell clients, those forms can change, and that form has changed this year, but the court will send you new forms. So the best thing that you can do is put a calendar note for yourself. You know, most of us have these things now, you know, they're in our pocket. We're on them all the time. Give yourself a calendar reminder. If I haven't received something from the court, let me call and check. You don't want to have to go through that initial process again. Okay, so you just kind of like other important things in your life. You just want to be cognizant of the deadlines and the times and when you got to do things and just keep an eye on things.
Thank you so much, Melissa, for all of your help today. This has been so informative and so great. And like I said, if you have more questions that you wanted to ask Melissa, but you didn't get to it, or maybe you want to ask it in more of a private setting, please reach out to her. She is fantastic. And thank you, all, of course, for having us, for being here with us and taking the time out of your day. I hope you found this webinar helpful. All of our webinars always live on our YouTube channel. You will receive a copy of this one after, later on today. If you have any questions, we are here to help. Please reach out. Veronica,
We're going to send you guys, like Michelle is telling you guys, an email with the slides, with the presentation slides, and the YouTube link. If you want to see the webinar again, we are going to share that information too. So thank you so much, everybody, and Merry Christmas, like it says in the chat box to everybody, and see you guys next year, hopefully.
Merry Christmas. Yes, you'll get all of our contact info in the email. All right. Have a great day. Merry Christmas. Bye, everybody.
Bye. Thank you so much, Miss Melissa.
Thank you. You have a Merry Christmas, okay?
You too. Bye-bye.